The next matter to come before the court this morning is the City of Akron versus Ron Easley. Ron Easley versus City of Akron. Each party will have 15 minutes in which to present your case. You're the appellant, and you should retain some of that time for up to 5 minutes for rebuttal. I'm keeping track of the clock, and we'll keep you apprised of the passage of time. We are being visually and audibly recorded to be posted online, so please try to remain behind the podium as much as possible. We have read the briefs and we're ready to proceed when you are.
May it please the court, I'm here today, Your Honors, to appeal the trial court's decision that had granted a default judgment stating that the default judgment stated that I failed to perfect my appeal. Failed to perfect, the appeal to the housing court. I didn't get a chance to respond to that motion because I was never served the motion. The opposing counsel for the City of Akron served the certificate of service. It was sent to the electronic filing system, which I was not party to. As a pro se, in this case, I was a plaintiff because it's an administrative appeal. So I never received notice. The Ohio Rules of Civil Procedure 5B F. I'm sorry, 5.2 states that Rule 5B2F says that service is not effective if serving party learns it did not reach the person served. And the service obviously didn't reach me. I wasn't able to respond. And because of that, I received a default judgment. So my case was never heard before the trial court. This is a case that involves the possession of property, which is ingrained in our Constitution, Article 1, Section 1, the right to a person's property. And that's what I'm trying to preserve. The city is trying through their administrative procedures to basically take my property, which I don't agree with, and which I'm trying to prevent. And so I'm just asking the court to allow some sort of due process where an independent review of the case can take place, because so far the only thing that's happened is the City of Akron has made allegations, the City of Akron has made their own findings, presented their own evidence. I wasn't party to that as well, and made their own rulings. It's never been reviewed by an impartial, it's never had an impartial review. So I've never had due process in the taking of my property. I'm only asking that the court return this case to the trial court so that at least I may proceed through this administrative procedure to try to preserve the rights of my property.
You did file some documents with the clerk of courts. Did you file your notice of appeal with the clerk of courts?
Yes, I did timely file that.
Did you notify them that?
Yes, I did.
Did you notify them that you were not participating in the electronic filing system that they use?
No, I didn't know that it was required. I wasn't even aware that Summit County had put this into their system somehow.
How did you file your notice then?
In person.
At the clerk's office?
Yes, Your Honor. Yeah, I filed in person, and I've been engaged with the court system before. I think this is somewhat of a new system, like electronic filing system, because I've always had service, just received mail service, or I would look it up on the docket and try to keep an eye on the case online. But in this case, I didn't receive the notice.
Did you have to file a document statement or something at the clerk's office?
Yes.
Did you include an email address in that?
No, I didn't. There was no application. I called the clerk's office.
I'm saying when you filed your documents in the first place, there was no place to enter an email address or anything that you filed?
I didn't see anything about it. No email. Just party addresses, and that is what I remember putting in there and how it was presented. I did call the clerk's office and ask them about that. I said, "Is this electronic filing system mandatory for the party?" They said no. It's just a selection that you can elect to do it. I suppose most attorneys, they correspond that way, but being a pro se defendant, And I've been corresponding with the city of Akron, through mail, but I didn't receive any mail service or any service whatsoever. So I didn't receive their motion for default judgment, or I would have responded to that. So without a response, the court just took upon their statements as facts, even though their facts are not true. They stated that I didn't correctly notify them of the appeal, which I did. I had a timestamped copy from the law department, but I went actually 3 days before I filed my appeal, but yet they claimed that I didn't give them notice about the appeal. It wasn't until the appeals court actually served them like some 90 days later, but it's not true. I have a timestamped copy of the notice of appeal prior to filing the appeal. So I did perfect the appeal according to the provisions of the administrative civil code. Had I had an opportunity to present that to the court, I could have progressed in my case rather than having the default judgment rendered against me for without my response, because I didn't get service of their motion for default judgment. That's all I've got.
Okay, you can have 5 minutes left to respond. Go ahead.
Good morning, Your Honors. Brian Bremer on behalf of the City of Akron and the City of Akron Housing Appeals Board. I want to first draw attention to something that Mr. Easley just stated, which was he admits that the entity that he gave the notice to prior to filing it with the trial court, or the common police court in this case, was the City of Akron Law Department. The City of Akron Law Department is not the entity that made the decision. It is not the administrative body. This court has held that serving the law department is insufficient to perfect the appeal under 2506.04. Mr. Easley has just conceded basically that his entire appeal was moot on that basis because he never properly served the administrative body he needed to, which was the entire basis of the motion down below. And by actually turning to his actual arguments on appeal, his brief is devoid of any citations to the record. He doesn't have any citations of any authority in support of his assignment of error, which is that he did not receive this motion, therefore the court's decision needs to get reversed. This court's repeatedly held that even when people are pro se, they get some leniency, but they have to still abide by the appellate rules. And when Mr. Easley doesn't develop any argument, doesn't cite any authority, doesn't even base it on the record, he's failed to actually demonstrate reversible error on appeal. And for that basis alone, his decision, his assignment of error should be overruled. Furthermore, the record doesn't contain, does not support Mr. Easley's a statement that he did not receive notice. It is actually silent on the issue. There's nothing in the record that shows whether he did or didn't, was or was not part of the electronic filing system, at least on the appellate record here. And when you can't support your basis for your assignment of error by pointing to something in the record, this court has repeatedly said that you cannot reverse what happened. In this case, I also wanted to just bring up real quickly, Mr. Easley is pro se. Mr. Easley, I can't speak to whether or not what he was told by the clerk of court's office. That's outside the scope of what I'm aware of. But I will tell you, the clerk of courts has it's very easy to sign up for as a pro se person for the electronic filing system. There's no reason to presume that he didn't do that because it's a simple click on the website. And if you go to the clerk of court's website, you basically register as a non-attorney.
Oh, that's probably outside the record.
It is, but I'm just explaining a little bit from Mr. Easley was discussing a lot of that, and it just is worth noting that it is not a complicated process. But you're
Since we're going there, do you know whether or not they direct pro se individuals?
I cannot
cheat or anything.
I don't know. I will tell you that the local rules that are on the clerk's office website do say that you have to register, that you do have to be part of the electronic filing system. I will also tell you though that based on my review of the rules that are actually linked from the actual Court of Common Pleas, that requirement appears no longer to be the case necessarily. You can still choose to register, but the actual local rules appear to be different than what are on the clerk of court's website. That's why we did not take the position that he had to register in our brief, is just because the local rules seem to have changed. But regardless, there's nothing in the record to show that he did not receive service. So to the extent he wants to make that argument, that's outside the scope of what's actually before you here on this appeal.
Well, let me ask you a question. I noticed in the brief it says, the motion contains a certificate of service asserting that the city served him through the electronic filing system.
Correct.
So unless there was an address there for you to serve to, how can you assert that you served him unless there was an email address for you to be sure that it got to? Or is that not your responsibility, that's the clerk's responsibility?
Well, the electronic filing system, as far as that, if we serve it through an email, that's a different section of the civil rules. Civil rules email service is something that we are doing. We can email him directly. We did not have an email address for him. We use the electronic filing system, which would go to an email address, but that is not something that we would have been aware of at the time of filing that certificate of service necessarily.
So it would be the clerk's duty to serve it.
Correct.
Okay.
I would say that I am not aware of what the situation was at the time, like when it was filed.
Of course, the clerk sends out certified mail, comes back on claim, you're notified. Does a rule provide for any notice if a party is not served electronically, that service has failed?
There's nothing like that I'm aware of, but typically, I'm not, what the clerk sends out is, again, that's outside the scope of what this record is, and that's kind of what a lot of this appeal makes this appeal difficult for Mr. Easley, is the fact that much of what he's arguing, the entirety of what he's arguing is not here with you. It's about the internal workings of the clerk's office, what was sent, what wasn't sent, and that's not part of this appeal. And so to the extent that he has an issue, there are other avenues that he could maybe pursue, but it's not here. And that's why what he's arguing right now is not he should not be able to proceed on this basis. And I also want to just touch briefly on, there's a passing reference in his statement of facts to the idea that the certificate of service refers to a notice of appearance as opposed to the motion to dismiss. He doesn't develop an argument on that about why that would not be sufficient. The certificate of service contains all the information that's required by the civil rule. There is a clerical error in the certificate of service that was attached to the motion to dismiss. It does refer to a notice of appearance as opposed to a motion to dismiss, but Mr. Easley does not explain why that clerical error would render the certificate of service insufficient for the purpose of this appeal. But I would again point out that his concession here or argument has rendered this entire thing moot. The trial court's decision was clearly correct because he did not prepare this appeal on time. And there was nothing he can do there's nothing he could present to the trial court that would have, even assuming he hadn't been served, even assuming that he wanted to respond, what he just said he wanted to submit would not have done anything to the subject matter jurisdiction of the trial court in this case.
Because he was out of time.
Well, it wasn't that just that he was out of time, which he was when he actually served the board. What he's claiming was the service to the board was he served the Department of Law for the city of Akron,
Right.
which is not the board that made the decision. And
Well,
that's
assuming he had served the board, he would have been out of time, is your argument?
if he had served it when he served the
Yes.
law. No, that would have been timely.
Okay.
But there's no even here on our argument, he doesn't say that. He
Right.
says he served the law department.
I understand.
Yeah. So, for those reasons, the city would respectfully request that this court affirm the decision of the Summit County Court of Common Pleas and overrule Mr. Easley's assignment of error. Thank you.
Thank you. So you leave that 5 minutes, sir.
Okay, the first point I want to address is this issue of whether or not I notified the law department in the city of Akron according to the rules to notify them prior to the appeal. Not only did I serve them at the law department, I also served the Housing Appeal Board, Department of Neighborhood Assistant. I served both. It's only the one from the Akron that I have a timestamp copy of. There's no receipt you get when you serve the Housing Appeal Board. So I served both, and it's in my brief that I served both. However, that's not what's at argument here today. That's something that the trial court would review if my due process was allowed to take place in this case. I would be able to present that argument to the trial court. And as far as their argument of me not citing something in the record concerning this, the very point is there's an absence in the record. I can't produce something that doesn't exist because there was nothing that was served to me. There's nothing to show in the record as far as me not getting service. I'm being asked to provide something that doesn't exist in the record. And the mere absence of that shows that I didn't get served in these proceedings. I think it's pretty clear here. I don't think this is a real complicated case here to look at and see that I was not part of the electronic filing system. I didn't get served. The rules of procedure clearly state that if the party does not, in the Ohio Rules of Civil Procedure 5 under Section B, it states there that the serving party, it's not, excuse me, that under Rule 5B2F, that it's not effective if the serving party learns it did not reach the person served. They've learned that, they know that it didn't reach me. They've admitted to that. So they know it didn't reach me. They're trying to make an argument that somehow, doesn't matter if it didn't reach me, that, through somehow through the rules of procedure that I didn't comply with something, so my argument is mute. But I think that the record does reflect I didn't get served notice, and I did not have time to respond to their motion. And had I had time to respond, I could have raised the arguments about whether or not my original appeal was timely with the court. That's all, Your Honor. Thank you.
Okay. Thank you. Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides as well as posted to our website and the Supreme Court. Thank you, gentlemen.